Welcome back, everybody. So in our last video, we tried to make sense of the Achbita versus G4S judgment using the phi-rack method. This method was meant to help you navigate the judgment and really extract the core argument from the case. In this video, I'll be discussing some concepts from international law that would hopefully help you make sense of this system that we call international law. So if you read a lot of news articles, you've probably come across an article that goes a little bit like this. Country A violates international law and gets away with it. Now, these types of newspaper articles say a lot about how we view the law, right? We often, even subconsciously, assume that whenever we're talking about a legal system, that it has to be sort of based on a system of coercion, where if you violate a rule, you get punished by a higher authority. Now, with international law, the situation is somewhat different because international law relies to a great extent on cooperation rather than coercion. And there's a good reason for this. At least in a legal sense, countries assume that they are equals to each other, which means that no country can impose themselves as an authority onto another country, right? So we are equal. So as a state, you would not be in a position to punish me because we're all on the same level. Now, this wasn't always the case, and I think it's important to acknowledge that international law does have a somewhat ugly history. Think of colonialism, for instance. But what I want to talk about today is that there are also highly developed international legal systems that work, right? Where countries, as a rule, comply with their international obligations. So in international law, there's an important distinction between private and public international law. Basically, private international law covers agreements that have been made between individuals. And then the question is often, okay, which law of which country should be applied to this dispute? And public international law governs the agreements and international obligations between states. So the concepts that we'll be covering today will help you understand judgments made by international courts, and specifically they will help you comment on those judgments. So that's really those were basically the selection criteria for the concepts that I will discuss with you, and they are roughly in order in which you might find them in a judgment. But some of the concepts that you would need to understand, such as, for instance, sovereignty or statehood, they play more in the background, in the sense that if you don't understand what sovereignty is, you might not understand why a judge doesn't go all the way and tells a country what to do. So the first question we'll be looking at is who gets to go to court and under what conditions? So historically, the business of public international law only concerned other states, right? So if you were a state and the other contracting party, the other state, didn't keep up with their end of the deal, then you could go to court and then you could, settle your disagreements. Now, however, citizens are being given a more active role to play in international law because states have realized that instead of litigating, these disagreements by themselves, if they allow individuals, companies, and NGOs to actually keep track of what other countries are doing, that's maybe a more efficient way to ensure the compliance of all of the states that are involved. Admissibility is something that refers to all of the sort of procedural requirements that you have to fulfill in order for your case to be admissible. If we look at the Achbita case, for instance, the only reason that the case ended up before the Court of Justice of the European Union was because the national court had decided that it didn't know how to answer the question, and therefore it referred the question to the Court of Justice of the European Union, which meant that Miss Achbita now had standing, right? She had a right to appear before that court. And because the National Court sort of fulfilled all of the criteria in order to submit the case to the Court of Justice of the European Union, it was considered admissible. Now, this is often a sort of invisible aspect of international judgments because judgments, or rather cases that are considered to be inadmissible, often go unnoticed, right? They don't really get a lot of attention in the press. And most often, if you look at the European Court of Human Rights, for instance, most cases do not fulfill the requirements, either because the individual submitting it doesn't have standing or because the admissibility criteria have not been fulfilled. And that means that the cases that we do get to see, right, have usually been through a rigorous sorting process. So be aware of that whenever you're looking at judgments, because it might give you a sort of biased opinion of how these courts, empirically, how they tend to rule on certain questions, just simply because there is a whole sort of invisible area of cases that go unnoticed because they've been declared inadmissible. I think it's also important to stress that certain parts or certain systems within international law only allow states to participate, right? So that's a really important thing to be aware of, because it means that if you are not recognized as a state, if you do not fulfill the legal conditions for statehood, then you might not be able to use certain legal procedures, for instance. So that might be a question that precedes the question of standing or admissibility. And there, the legal debates or the theoretical debates are somewhat more murky. Essentially, there are two schools of thought. The first school of thought says there are basically three criteria that you have to fulfill. If you fulfill those criteria, that's it. You should be considered a state, right? So if you have a permanent population, if you have a defined territory, if you have a capacity to enter into relation with other states, that's all it requires. There's another group that says, yeah, maybe, but you still need to be recognized by a wide group of states. Otherwise, what's the point? Because nobody's going to enter into any treaty relations with you. So you might as well not be a state, right? So there, I leave it up to you. That's a discussion that you can read up on and make up your own judgment. But why is this important? This is important because there are a lot of sort of general principles that you have to keep yourself to if you are considered to be a state, and that other states that sort of take part in the global community, they have to respect those principles in relation to you as well, right? So for instance, this principle of non-intervention, where basically everything that happens within your country is your business and I shouldn't intervene if I'm a big, strong state. That's something that would apply if you would be considered to have statehood, right? Because that would fall under your sovereignty, right? That would fall under what you would be considered responsible for and what you would have the power to decide upon, right? That's sort of this idea of sovereignty. An important principle I want to stress in this relationship, in relation to this, is states are, or international law, as I mentioned in the introduction, is very much based on cooperation rather than coercion. So there are all of these international conventions, but if you're considered a state, it means that it's your prerogative. You get to decide whether you want to sign up to these conventions or not, right? So just because there is an international convention doesn't mean that it's going to apply or apply to the same effect across the entire world, right? So that's an important thing to keep into consideration whenever you read these news articles that say, oh, but it's against this convention. Because if that state didn't sign up for that convention, yes, it might be, immoral, but it doesn't mean that it would get them into legal trouble necessarily. Another point that I want to stress is that international law is not only something that you use before international courts, right? So international law can be applied in a variety of ways before national courts as well. And in fact, that's the sort of ordinary course of events, right? So if there is a specific convention that a state has to keep up with, or that sort of imposes certain international obligations, national courts would be the first place where that international obligation would be litigated. Now, there's a difference here between the constitutional traditions of different countries. Essentially, if a country is monist, any international treaty that has been signed and ratified automatically becomes part and parcel of national law. So a judge doesn't have to think about whether or not it's allowed to use a rule. It will just be able to rely upon it directly. So if there is a judgment by, let's say, an international court that interprets a rule in a certain way, then that judgment can also be relied upon in a monist country. As soon as a treaty is signed and ratified, that rule becomes part and parcel of national law, so you can rely upon it, you can use it. In dualist countries, the situation is a little bit different. In dualist countries, you can think of it as two separate legal orders, where international law isn't really the business of national judges. Government has to actually transpose these international rules into national law, and then you are allowed to use it. International law itself doesn't usually care whether you have a monist or a dualist system, as long as you keep up your end of the bargain. So suppose that you are a state, and suppose that at the national level, the courts have not been able to ensure that you keep up your end of the bargain. Then the question becomes, okay, so suppose that we go to court, where do we actually find international law? Where do we find these relevant rules? And a really good place to look, or a good place to start, is Article 38 of the ICJ statute. Essentially, the ICJ statute gives us three important sources of international law. The first one are conventions and treaties. And here I want to stress that just because two states signed a piece of paper doesn't mean that it's necessarily a convention or a treaty. Sometimes these diplomatic statements aren't meant to be sort of legal documents. They just serve a diplomatic purpose. So that's something that's worth verifying. The second one, international custom as evidence of general practice and accepted as law. This is a bit more tricky, but I mentioned the principle of non-interference, for instance. That's sort of a customary principle because it's not just a rule that states keep to, it's also a rule that they believe to be a legal rule, right? So if we speak of custom, it might be customary to roll out a red carpet whenever a royal family visits your country, but that's not something you do because you believe it to be a legal obligation. It's just something that you do because you consider it to be sort of a polite thing to do, right? General principles are basically principles without which the legal system wouldn't function, right? So for instance, agreements should be kept to, right? If we take that as a principle, and you remove it from the legal order, all of a sudden the legal order stops functioning. All sorts of crazy things happen. The fourth bullet point is sort of a subsidiary way of clarifying the first three. So suppose that it's not entirely clear whether something is a custom or not. You would be allowed to look at judicial decisions and publications from the most highly qualified publicists as a guiding sort of tool to help you ensure that you found the correct interpretation of a specific rule. Now, I mentioned earlier that you actually have to sign up for these specific conventions in order for them to become a source of law for you. But international legal systems have a way of sort of indirectly influencing each other. A good example of this, in the Achbita case, the Court of Justice of the European Union actually refers to the ECHR, but the European Union is not a party to the ECHR, so they don't have to, right? But they still take inspiration from it for all sorts of technical reasons. But I want you to be aware of the fact that these different legal orders that require you to sign up for you're required to sign up for every single one, but they might still influence each other and take ideas from each other, and that way still have an impact, even though you might not have signed up for them, right? So that's an important lesson to take from the Achbita case. So it's important to realize that although these international courts have a lot of authority, they're not omnipotent, right? Their power is not unlimited. They have to stick within certain rules when it comes to their jurisdiction. Now, when it comes to jurisdiction, I think it's important to realize that jurisdiction has many different dimensions, right? So you could, as a court, you could be limited in terms of what time period you can look at, what geographic locations you can take into consideration, but also what types of material questions are you allowed to answer, right? And this is very much going to be defined by what the states agreed to. If you are looking to comment on a judgment, please make sure to verify that the court could actually decide, on the case in the way that you think the court should have decided it based on the jurisdictional limitations that this court faces as well. But suppose that there is no sort of theoretical complication as to which rules you should be using as a judge. Then there are still some guides or some basic sort of methods that you can use as a judge to interpret rules. The first one is obviously literal interpretation. I don't think that requires a lot of clarification, but suppose that that's not possible, right? Suppose that the literal meaning of a phrase is not clear enough for you to use as a judge. Then we move up a step and we sort of abstract from the drafting documents of a specific rule what the person who created the rule intended with what goal they intended to achieve, and how specific words should be interpreted. And if we go sort of a step higher on the abstraction ladder, then we look at teleological interpretation. And the difference here is where, when it comes to legislative intent, you would look at sort of the phrasing and the words that were used in the drafting documents for a specific rule. The teleological interpretation looks more at the specific purpose of a specific rule within the sort of greater whole of that system, and tries to figure out, okay, so if we need this particular rule to function, what should it do? How should it work? Right? So this teleological interpretation also keeps rules up to date, right? So these three different ways in which rules can be interpreted increase the level of abstraction with every step along the way. And the second and the third, there is a little bit of an overlap, but the second one tries to stick more with the literal words that were used in the discussions or during the meetings about the creation of the particular rule. And the teleological interpretation also allows a judge to think about what that rule would mean in the current historical context, for instance. Then there are also some really basic rules of interpretation that usually play a little bit in the background, where if, let's say, a rule is of a lower rank or was created by an authority that has a sort of a lower rank, then the rule that was created by a higher authority usually takes priority, right? And when it comes to new rules versus old rules, new rules tend to take priority. The same goes for specific and general rules. This is something to keep in mind whenever you're looking at how a judge is interpreting specific rules. Now, all of these rules might create the impression that a judge doesn't actually have a lot of leeway when it comes to how a specific rule should be interpreted. And I want you to have a critical look at the Achbita case, because the way in which the judge uses jurisprudence, right, makes it seem as if the conclusion is inevitable. That's very much the writing style in judgments. And, we talked in the first video about inductive and deductive logic. So there's a good reason for that as well. But I want you to reflect critically on the fact that, the judgments that are referenced here um, do not bind the court, in the sense that the Court of Justice of the European Union doesn't actually have to uphold older decisions, right? It has the freedom to say, okay, in that judgment we said this, but now we are going to interpret it in a different way. Why is this important? Because I think the conflicting rights in the Achbita case actually really clearly demonstrate how the court balances certain values, right? So the freedom to conduct a business on one hand, and the prohibition on discrimination on another, or the freedom to religion, depending on what you focus on. And then it strikes a certain balance, right? And that balance is something that we can look at through different ethical lenses and different legal theories. And that's what we'll be doing in the next video. Thank you very much for watching.